Hi, I'm Kevin Donnelly, and this is my Gideon versus WainWright presentation and breakdown. Clarence Earl Gideon was a rough child growing up who dropped out of school when he was in 8th grade, and he was in and out of jail for minor crimes and minor charges until he was eventually charged with breaking and entering, which is a misdemeanor in Florida, and was facing up to 5 years in prison. Because Gideon is a mentally unstable person and dropped out of school in 8th grade, when it was time to actually go to court and he couldn't have a lawyer to represent him, he had to represent himself and was up to face it, and ultimately, of course, found guilty. He then went in jail facing 5 years. He wrote a habeas corpus to WainWright to go to the Florida Supreme Court to challenge how unethical and how fair his trial. The lower court trial judge denied Gideon's request for a court-appointed attorney because under Florida law, counsel could only be appointed to a poor defendant who was charged with a capital offense. And since breaking and entering is not a capital offense, the court had all the right to deny all relief. Gideon sought relief by filing a petition of writ for habeas corpus to the Florida Supreme Court. The petition included him challenging his conviction on the fact that the trial judge refused to appoint him counsel, and that it was a direct violation of his constitutional right, which they completely denied in whole. Petition before the Supreme Court. Gideon argued that he was treated unfairly and he was denied a lawyer. Gideon was an 8th grade dropout as he did not have the education nor mental skills as he was in and out of jail to properly defend himself in a trial. Trial breached his 6th Amendment, which was the right of a fair and speedy trial, as it obviously was not fair. For the defendant, as WainWright, Gideon was a repeat offender as he has been in and out of jail for small nonviolent crimes, but could argue that it would only grow or only be in jail more often. Although he wasn't a lawyer, he still prepared and defended himself in court and fully explained his situation to the jury, which they said he was guilty to. And his last point is that the trial judge denied Gideon's request because Florida law only permitted appointment of counsel for poor defendants charged with capital offenses, meaning that the law was already in place for him to be denied. The Supreme Court majority opinion, and on March 8th, 1963, on an unanimous vote, the Supreme Court agreed that it was a direct violation of his 6th Amendment and it was a capital right to be appointed counsel to criminal defendants. The majority opinion was written by Justice Hugo L. Black, and it describes how Gideon was unfairly treated in court in Florida and goes how they violated his 6th and 14th Amendment by unfairly putting someone on trial and putting his life on the line without due process of law. Then concludes that his case overrides Betts v. Brady, where a man was denied counsel and his appeal was denied by the Supreme Court. There was no dissent opinion as it was a unanimous decision, and one of the concurring opinions was wrote by Justice Clark, and he talked about how everyone deserves a counsel for protection of due process as law, as if everyone doesn't get a proper say in which they have, or of proper say and explanation of what happened in their situation, it can only further damage our country. It ensured under the Constitution that the states must provide defense attorneys to criminal defendants who are charged with major offenses and cannot afford a lawyer themselves. It allows fair treatment for anyone under the law, as without protections like this, poor and mentally unstable people would be able to be imprisoned at much higher numbers than other people in our country and would leave injustice.